were present and those who had come to listen to his arguments, during those days, they were unanimous in the view that here is a great jurist in the making. So, the structure of the Constitution in 2017, Justice Rao was part of the 7th Constitution bench, which held that appealing to the ascriptive identities of candidate or voter would amount to a corrupt practice under Section 123 of the in 2017, in the case of Krishna Kumar Singh versus State of Bihar, Justice Rao was part of the 7-judge Constitution bench, held that re-promulgation of ordinances is unconstitutional on the Constitution. In March 2020, Justice Rao authored a landmark judgment in Indian Social Action Forum versus Union of India, holding that support to public causes by resorting to legitimate means of dissent could not deprive an organization of its legitimate right of receiving foreign contributions under the Foreign Contribution Regulation Act 2010. The bench led by Justice Rao during the COVID-induced national lockdown in 2020 directed the state governments to ensure that dry ration was provided to the sex workers without insisting on any proof of identification. In the same judgment, Justice Rao issued a slew of directions concerning rehabilitation measures of sex workers, including that basic protection of human decency and dignity extends to sex workers and their children. Justice Rao was also part of the special bench on COVID-19 management in the country that observed that policy of the central government as to paid vaccinations for persons in the age group of 18 to 44 was arbitrary and irrational. Because of this judgment, the government was compelled to review its making vaccinations free for all. Justice Rao also headed the bench which suo motu heard a case concerning orphaned children in the aftermath of COVID-19 crisis. The bench directed the states and the union territories to link the orphaned children and their family members to various welfare schemes. Justice Rao was also instrumental. Rather, he penned a significant judgment in Jacob Pulial versus Union of India, holding that bodily integrity is protected under Article 21 of the Constitution of India. No individual can be forced to be vaccinated. Justice Rao also came to the rescue of a renowned journalist from the Northeast, Patricia Mukim, who was booked for her Facebook post condemning atrocities on non-tribals in Shillong. The bench quashed the FIR against Mukim, even as it denounced the stifling of free speech by implicating citizens in criminal cases. In May 2021, a 5-judge Constitution bench, of which Justice Rao was a part, struck down reservations to the Maratha community in the educational institutions and public services provided by the Maharashtra government by declaring them as educationally and socially backward. In National Highways Authority versus Pandarithan Govindarajulu, Justice Rao-led bench observed that while economic development should not be allowed at the cost of ecology or by causing widespread environmental destruction, the necessity to preserve ecology and environment should not hamper economic and other development. Both economic development and environment must go hand in hand. In a decision concerning Unlawful Activities Prevention Act 1967, Justice Rao-led bench held that payment of extortion money did not amount to terror funding while granting bail to a businessman. Again, in a significant ruling, a bench led by Justice Rao directed the Madhya Pradesh High Court to reinstate a woman additional district judge who had resigned from her service alleging sexual harassment by a High Court judge. The bench, which also comprised Justice B.R. Gavai, held that the resignation tendered was not voluntary and set aside acceptance of such resignation. The judicial officer was directed to be reinstated with all consequential benefits, including restoration of seniority. The list is endless, friends. However, before completing this part of the narrative, what is discernible is that in almost all cases involving confirmation of death sentence, which came before the bench led by Justice Rao, or a bench of which he was a part, invariably the bench had commuted the death sentence to life imprisonment. Justice Rao is not only a great lawyer, a great judge, and a great jurist. He has traveled much beyond these fields. He was a cricketer of considerable repute during his younger days and was instrumental later on in supporting advocates' cricket tournaments in the country. I had the good fortune of watching Justice Rao in action as a cricketer in a cricket match between CGI Bobday 11 versus Bar 11 in the Brabourne Stadium in Mumbai. True to his principles, Justice Rao, despite going strong after scoring heavily, retired, thereby giving opportunity to the other judges who were waiting for their turn to bat. But this came at a cost, as the later batsmen failed to keep up the momentum of run scoring by Justice Rao, and in the process CGI 11 lost. This morning in the breakfast table, my daughter has informed me that there is another side to the personality of Justice Rao. There is another trait. She told me that in 1989, Justice Rao had acted in a Hindi film called Kanoon Apna Apna, again dealing with Kanoon law. In one particular scene, Justice Rao acted as the inspector of police along with other Bollywood actors. We do not know how and in what way Justice Rao ended in Bollywood. But one thing is sure, going by the high standards that he maintains, if he had continued in Bollywood, he would have also made it quite big. Friends, whether it is on screen or in the cricket field or in the courtroom, either as a lawyer or as a judge, Justice Rao always stood for fairness and fair play in action. And this is the very essence of the rule of law and the justice dispensation. We have all gathered here and are waiting impatiently to listen to Justice Rao. I will not come in the way any longer. I would therefore request Justice Rao to deliver his speech. Sir.
Thank you. Thank you very much, Justice Buyan. I don't know whether I deserve all the accolades. Justice Buyan, the Chief Justice of the Telangana High Court, judges of the Telangana High Court, the Advocate General of the State of Telangana, Chairman Bar Council, President and members of the Executive Telangana Advocates Association. My dear friends, there is a feeling of acute nostalgia when I enter this hall. Just before I left Hyderabad in 1995, as the President was saying, I was the Secretary of the Association. I bid farewell to a number of judges from the very same place, welcomed a few of them, and I also bid farewell to this High Court in search of greener pastures, if you can say. This is my parent court, and whatever I am today is all because of this court, mainly my senior, Mr. Y. Suryanarayana. I worked with him for 5 years. I learnt everything from him to start with. And that would show the importance of having a good senior at the start of your profession. Roscoe Pound said that there are 3 main attributes to a legal profession. One is organization, 2 is learning, and 3 is public service. Organization, you have an organization of an agglomerate of lawyers who would definitely work for public service. The profession is mainly intended for public service, is what Roscoe Pound said. He was a legal scholar. He was a professor in Harvard University, and his books are very well known in law. I would start about learning. Why is learning very important for lawyers? At the outset, I should congratulate the Advocates Association for starting this lecture series, especially on issues of constitution, which are very relevant for lawyers who are practicing in the high courts. And it would definitely generate more interest in youngsters to continue learning. It's not only youngsters who have to learn, but even persons who have put in long number of years, they also should continue to learn. A lawyer is always a student of law, and the number of years a person has spent at the bar would not really show his proficiency in law. He would continue to learn law. That's the importance of learning. I was walking into this hall, and I was reminded of my friends with whom I used to sit in the corner, the sofa. So one of my friends in the morning, 10:30, when we walked in, we used to ask him, "Haven't you gone to court?" He said that my work was over last night. So we used to ask him, "How last night?" He said, "I saw the cause list, there's no case. So finished my work last night itself." And when there were discussions about reading books and presenting your cases properly, citing case law, one of my friends used to say that, "Why should we read? Any of the judges are not going to hear us, and judges are not so intelligent to understand what we are saying. So there's no point in reading." And I remember one friend of mine telling me that a lawyer's job is very difficult, judge's job is very easy. And I asked him, "How is it easy?" "What is there? You can record the contention." So the petitioner is a petitioner argued like this, then say that the respondent has responded. Then they say, "On a conspectus of the above, this is my decision." It's as easy as that. It's a lawyer who has to go and place his case before the judges. Mind you, friends, that a judge's job is much more difficult than that. In the 6 years of being a judge, I found that the amount of work a judge does is almost double the amount of work a successful lawyer does in his office. Justice Boyan was mentioning about the reason why I declined in 2014. I never wanted to become a judge. It's only a weak moment that I accepted being a judge in 2016. I always enjoyed being a lawyer. My colleagues on the bench regularly used to ask me as to how I feel being a judge in the same court where I practiced for more than 20 years. So from the day I became a judge till the day I left the court, every day I was missing being a lawyer. You are in one of the most exciting professions. There's no other profession which matches the legal profession. Having said that, all of you might be having boards just outside your house describing yourself as so-and-so advocate high court. You owe a duty not only to the public but to yourself to read the Constitution because you are practicing in the High Court. If you call yourself a lawyer of the High Court, all of you should be well versed with the Constitution of India. When I say well versed, even if you start reading now, I'm talking to the youngsters, for the next 30, 40 years you might not be able to learn much about the Constitution. There's so much to learn and so much to contribute as a lawyer to the society. So I end with that learning being very important, and I'm honored that the association has asked me to deliver this first lecture, which is a series of lectures which they are going to have, where you would be hearing a number of people who would share their ideas about the Constitution of India and certain specific topics. I know of a few high courts where the High Court itself officially, through the Chief Justice, have started lectures. I got invitations during this COVID period to deliver lectures online from some high courts. Because if the association and the court gets together and starts lectures like this, it might be useful for the exchange of views on topics of interest and topics of relevance relating to the Constitution. I now start the task that is given to me about sharing my views on one right in the Constitution, which is social justice. If we start speaking about all the constitutional rights, I think it would be a series of lectures by me for the next 1 month or 2 months. So we will focus on social justice. On 26th of November 1949, we, the people of India, enacted and adopted the Constitution which would govern this country. We solemnly resolved to constitute India, and we also resolved to secure to the people of India justice, political, economic and social, equality, giving opportunities to everybody in status, liberty, which would improve the fraternity of people in this country. The source of the preamble to the Constitution is the people of India, that is all of us who are Indians. And preamble is a part of the Constitution, and wherever there is a gap or a grey area in interpretation of the Constitution, it works as a lodestar for the courts to interpret the Constitution. Justice, which you see in the Constitution, which is a prefix for political, social and economic, has nothing to do with judges. Justice here is justice which relates to distributive justice, which is to be done by the state. Justice is giving whatever is the best he or she deserves, and justice is always equated to fairness. Ambedkar, in his on 26th of November 1949, he mentioned about the task that he went through into the opinion of the majority. All points taken very well by the majority but were not included in the Constitution. He expressed his apprehension that it's all right, you would be having a political justice from tomorrow, that is, everybody has a vote, but when the country is still fractured on the basis of caste and creed, he said that he is not very sure as to when there would be social justice in this country. He expressed his fear as to whether there would be anybody else to blame for us for losing our independence. He said that we have lost our independence once, but we could blame the British. But he said now there is nobody else to blame if we do not follow the principles that are framed in the Constitution. He also said that caste is a national enemy, and it is always a mystery as to how all of us are together. He says unless people shed the feeling of caste, creed, religion and region, the country is not independent. Stress was laid on social justice because even Pandit Jawaharlal Nehru, when he spoke at the initiation of the Constituent Assembly in 1947, said that please bring a constitution which will bring justice to those teeming millions of people of India who have empty stomachs. The country was starving as the majority of people were half-fed. He said, please make a constitution which would take care of them. So social justice was at the heart of the persons who were making the Constituent Assembly, who are the framers of the Constitution. And that's how social justice becomes very important for all the lawyers to learn more about what justice is. I'll try to give you whatever I can in the next half an hour. But it's for you to go home and start reading the Constitution and finding out where the social justice is coming from. You have the fundamental rights. You have Article 14, which speaks of right to equality and equal protection of laws. As you know, by framing the Constitution, we framed all the best things insofar as rights are concerned. The right to equality was borrowed from the British. They don't have a written constitution, but the common law principles. And equal protection of laws came from the 14th Amendment of the US Constitution, which is the heart of which says that no state can deprive a person of equality before law and equal protection of laws. This is the guarantee that is given to every citizen of this country. And then there is Article 15, which postulates that there cannot be any discrimination of any citizen of this country on the basis of region, religion, sex, caste, etc., gender, etc. But otherwise, 15.4 enables the state to make laws for protective discrimination in favor of persons who are disadvantaged and who also belong to the marginalized sections of the society. Article 16 again deals with equality in matters of public employment. 17, you know, is abolition of untouchability, and I stop here insofar as fundamental rights are concerned, which are connected to social justice. Move on to the directive principles. In part 4 of the Constitution, you have a mandate in Article 37 of the Constitution, which says that though the directive principles are not justiciable or enforceable in courts of law, the state has to keep in mind the governing principles of the directive have been followed by the state, and many